That's a very bright light. Ladies and gentlemen, my name is Mike Hogan. I'm the Assistant Vice President for Development and Alumni Relations at the GW Law School. It's my privilege to welcome you all this afternoon to the fifth and final conversation with Supreme Court Justice Stephen Breyer, a true oral history of the arc of a great career. Justice Breyer, welcome back to GW. I'd like to extend a special welcome to our GW alumni and friends and various members of our GW alumni advisory boards who have joined us from around the country, including California, Arizona, Illinois, New York, and of course, here in Washington, D.C. It's now my great pleasure to introduce the Dean of the George Washington University Law School. Please welcome to the stage, Dean Dana Bowen Matthew.
So excited. I'm going to stay on script, though. Good afternoon, and welcome. I'm Dana Bowen Matthew. My pronouns are she, her, and hers, and I'm Dean of the George Washington University Law School. It is my great privilege to welcome you to this, the fifth and final installment of this Only at GW experience. The amazing series would not have been possible, so I'm already going off script to say thank you to our dear, beloved Alan Morrison, the GW Law's Lerner Family Associate Dean for Public Interest and Public Service Law. He has been a friend of Justice Breyer's for more than 40 years, and he has been a friend to me and this law school for over 12 years. He has made it possible, because of his deep friendship with Justice Breyer, for us to hold this incredible oral history of this incredible jurist. And now it's my great honor to introduce President Ellen Granberg. Now, you can read about the fact that she began her tenure as the 19th president of George Washington University on July 1st, 2023. And you can read her biography about the exciting academic leader that she was and is before she came here. And you can also read about her scholarly work as a sociologist. But what you will not read, and the thing that I must share with you to introduce her, is that we at the George Washington University are the recipients of her most remarkable accomplishments yet, in my opinion. President Granberg and her wife, Sonia Rankin, have brought a steadfast commitment to the highest values and purpose of higher education. They have brought steady and wise leadership, not only during turbulent times, but also during the times that we have learned to call joyful. They are smiles, they are fun, and they are everything that this community needed. Please join me in welcoming our 19th president, Ellen Granberg.
Well, good afternoon, everyone, and Dana, thank you for that extremely kind introduction. I have to say, this afternoon, I'm more excited than I have been at, I think, any time at my time at GW, because I've been an admirer of Justice Breyer for many, many years, and so the idea that he's here with us today is just enormously exciting. And so it is my great honor to welcome Justice Stephen Breyer to the George Washington University for this fifth conversation about his illustrious career. This conversation will focus on the Justice's time on the High Court and his new book, Reading the Constitution: Why I Chose Pragmatism, Not Textualism. I know we're in for a real treat. Most, if not all of you, know about the Justice's exemplary 28 years on the Supreme Court. And many of you are aware that he served for 14 years on the Court of Appeals for the First Circuit in Boston and was a law clerk to Justice Arthur Goldberg. Less well-known are his services in the legislative branch, twice working for Senator Ted Kennedy on the Judiciary Committee, and his stints in the executive branch, in the U.S. Army, and then in the Antitrust Division of the Justice Department. and finally as an assistant prosecutor in the Watergate Special Prosecutor's Office, not to mention his time on the Sentencing Commission while on the Court of Appeals. He's also much more than a lawyer, having had a major role in the design and construction of the magnificent courthouse in Boston while he was chief judge, which led to his appointment to the Pritzker Architecture Prize Committee, which awards excellence in architectural designs from around the world. On top of this, he reads and delivers lectures in French, which was not the language he grew up speaking in San Francisco. Justice Breyer is, in sum, a man for all branches of government, as well as a true 21st century Renaissance man. He'll be joined today by Alan Morrison, the Lerner Family Associate Dean for Public Interest and Public Service Law, who has known Justice Breyer for more than 45 years. Alan is completing his 15th year at the law school, where he teaches civil procedure and constitutional law. His biography, as well as Justice Breyer's, are in your program. It is now my great pleasure to bring to the stage Justice Stephen Breyer and Professor Alan Morrison.
Well, here we are.
Yes, here we are.
Here we are.
We've been going through 5 months of my life. Now it's time for your life.
Yeah. Oh, let me start with the beginning of the time in 1994 when you went on the Supreme Court. You had been in the Court of Appeals, you'd been a chief judge, been on the Sentencing Commission, you'd clerked at the court. Most people thought you were really prepared. When you went on the court, did you feel prepared for your new job?
What did I feel?
Yes.
Well, Harry Blackman, my predecessor, told me, you'll find this an unusual assignment. And indeed, I would say what I felt my first year or two, stark fear. I mean,
of what?
That's what everyone feels. Anyone who's appointed to the Supreme Court knows that lightning had to strike twice in the same place before you are appointed to the federal Supreme Court. And so you thought you could do the job. You thought so. And then you're there. And you wonder, inside, can I really? Can I really? A lot of people depend on it. And if you get any justice, I don't care how far back you go or when or whatever, but somewhere within them, those first 2 or 3 years, they're wandering around thinking just that, though they don't say it. And that's why David Souter said, it takes 3 years minimum. William O. Douglas said it takes 5 years. And you sort of adjust. You say, well, they'll just have to put up with me, and the most I can do is do the best I can. And that's virtually any job that you're going to get in the law or any other profession.
What surprised you the most about going on the court?
That I was chosen, frankly. I mean, that's the truth of the matter. And I got to the court. You're sort of on your own. There you are. You talk to people. You try to make it collegial. They try to make it collegial. But Tony Kennedy said that to a group of, oh, wait. First, I want to thank you for doing this, Alan. I mean, really, 5 of these that's very, 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 very decent of you. Thank you. And also, I want to thank GW for doing it, and the dean, very nice, and your president. We discovered we went to the same high school. Now, those were the days, I'll tell you. You think when you're in high school they're not the great days? Well, they are, okay. That's just about it.
That was before we came to GW, though. That's
Yes, well, it's great.
So what was the most difficult part of your transition to becoming a justice? Was it the breadth of the cases that you had, so much that you had never seen before, or what was it?
A lot was that. A lot. The most difficult part, actually, is, remember, 60% of the time, or 40% of the time, or something, we're unanimous. And we're deciding cases like, we had is the comma in section 4267 or something of the Internal Revenue Code, meaning the next word, which was for, should be read as a which or a that. We did have a case sort of like that. I liked it. Nobody else did. But
did you get to write that
you're
opinion?
actually I mean, what?
Did you get to write that opinion?
Probably. You see, you know there are going to be, and there are, quite vast areas of the law which you know nothing about, I know nothing about. And when I asked the bankruptcy lawyer in front of us in oral argument, you know, what's going to happen in the bar? What do you think will happen to the people in bankruptcy if we decide this way or that way? I'm not doing that to show I know something about it. I'm doing it because I really don't know. And he does know more than I know about it. And if the questions are working well, they're exposing areas that we don't know and that we think are relevant to the case and where the counsel knows something about it.
Did you have a justice or two who helped you at the beginning on their time in the court?
Well, let's see. It's hard to, I mean, Sandra and David Souter and I and Tony to a degree, but Sandra and we got on very well. And there is, what Tony said, but I was going to say what he told the Russian judges because it's so true. He was talking about judicial independence. And they were saying, they were talking to us, and they're going to end telephone justice. Ending telephone justice meant that it was no longer going to be true in Russia that the party boss would pick up the telephone and tell the judge how to decide. This was when Yeltsin was there. And he said, you know, independence is a funny thing. Judicial independence could not be more important. But are you being true to the record? Are you trying to eliminate considerations of personal popularity? Are you trying to decide this case in a way that is not just picking up some cliche? Are you actually doing you know when you are a judge that that is how you should behave, and you know whether you are or not. No one else does. The lawyer you decide in favor of will say, oh, he read the record brilliantly. The lawyer who lost the case will think, what an idiot. He won't say that, but that's what he'll think. All right? You know. Other judges, lawyers, others may know the feeling, but they don't know whether you are living up to it or not. But you do. And so you want to create conditions such that it isn't just something you say in a newspaper editorial or something somewhere else, that you really do it. And you'll see. He said, you'll know. I thought that was a very, very meaningful statement.
But not a specific technical part of your job. It was just some words of wisdom.
Correct. And I think they were good. The technical part is that I know that I will have a lot of cases to decide or be involved in, and you have to listen to other judges on the court. You have to listen to them, but you're deciding independently. And so you have to somehow come to grips with this area or that area or the other area. And sometimes it's easy. I mean, I taught administrative law, so I think it was easy, but even there it's not necessarily. No, we know that. But you know that's going to happen. It does happen. And you just do your best.
One of the most important parts of your job is deciding which cases to decide, the certiorari process. Did your use of the process change as you got on the court and evolve over the years?
A little, yeah. I mean, you think at the beginning, I mean, there are basically 2 or 3 rules of taking a case. The main basis for taking a case, which is probably 90% of them, maybe more, have the lower court judges come to different conclusions on the same question of federal law or the Constitution. And if they have, it should be uniform, so probably we'll take it. And if they haven't, why take it? You see, they're perfectly good judges. And that explains almost all, of the decisions to take or not take a case. And of course, the lawyers know that, and so they say there's splits in the circuits, and we have to look to see if there really is or not, or how important is it, et cetera. We'll also almost always take a case if a lower court judge, if the lower courts that we're reviewing have held a law of Congress unconstitutional. Not 100% of the time, but almost always. The third thing is harder because it's some sort of important case. We think it's very important. We think it's important that there be a Supreme Court decision and it doesn't meet the first 2 criteria. Guantanamo.
Or Bush versus Gore?
We had a little disagreement about that.
I noticed that, yes. It was a fairly...
But, yeah, so That's a hard category. Of
course.
And it was easier on Guantanamo.
Did you used to read the petitions yourself, or mostly rely on your law clerks?
No, most of the time, I mean, occasionally I'd read the petitions and the responses. But what happens is that a large number of us, maybe 8, 7, 8, 9 of us, pool the clerks. And so what we get is, say on Wednesday, a stack of memos. And they go through the arguments and so forth pretty thoroughly, and they look things up that need to be looked up, and they make a recommendation, but they'll summarize it. And then I go through it like this, and when I talk to the students about that, I say I reduce it to something like that, from say something like that, probably in a couple of hours.
Do your clerks look at them too, at the memos too, the petitions?
Do they look at the ones they didn't write?
Yes.
No, not unless I put them in the small pile. And the small pile, I usually say to the law students, I want you to think I can do that because I'm such a genius. Well, I'm not. I'll tell you something. I do it because I have the criteria that I just told you. And I can see what this case is about very quickly. And when I see what it's about, that usually disposes of it. But, and you would come to the same conclusions. You read them, you would come to the same conclusions. I believe it. But this is the stack where they're problematic or whatever it is. Then I give them to my law clerks. Then on the next day or two later, we send a memo around. The chief sends a memo and says, we should discuss at our conference Friday these. You see, you have a list there. Maybe 5, maybe 10, maybe sometimes 15. And then anyone on the court can add anything. Well, I was junior, for a long time, so the chances that I have something to add and nobody else did is not promising for the likelihood that the court will grant it. But sometimes I did, sometimes I would. And when we get that list, I then go back to my clerks and we discuss how probably I'll vote on Friday. And
On whether to grant.
Yeah,
Yeah.
grant or not. And then in the conference, the first thing we discuss is the status of the circulating cases. And we have a list, everybody's name, and everybody has circulated, and those who haven't circulated can look and see. And you think that this acts as a spur. No, it doesn't. When you have a list, it's probably true in a law firm too, of what everybody's doing, it really doesn't do any good because everybody just looks at his own name. But that's supposed to spur things on. All right. The second thing we do is the cases that we heard that week. The third thing we do is the certs. All right. When we go to the certs, the chief starts and he says briefly maybe what the case is, and he says no, or we'll go around. Somebody will say yes, and then we have a little discussion about it. And if there are 4 votes to grant, we grant. Now the fail-safe is if I hear somebody say something, and I hadn't really paid enough attention to it when we were discussing it with the clerks and so forth, I'll say hold it over a week. Anyone can say hold it over a week, or you can say hold it over 2 weeks. You can keep going as long as you want. But if I'm holding it over, then when I get back to my office, then during the next week, my clerks will go look up the things that are questionable. I'll get their memo out. Then I go back to the briefs, you see. And if it's questionable in my mind. I suspect on the certs, the ones that are disposed of, which is certainly most of them, without much consideration, without much thought, I suspect that take this audience, you would come to the same conclusions. I think so. I'm not positive, but I think so. So it works fairly well because of the strictness of the criterion that we want to split in the circuits before we're going to take a case. You probably can't do much harm by not taking a case.
Except to the lawyer who filed the petition. So,
he just tells his client, I thought it's very rare.
do you think you were more generous or granting cert earlier in your career, or less generous, or how do you think?
Yes, I do. I do.
You were more generous?
I was more generous at the beginning because there would be things that I would think, perhaps rightly, that I didn't know anything about. And I'm nervous about that. So I'll lean more in the direction of, well, maybe this is an issue or not. Later, you've seen things before. Douglas said that at 3 years, and they begin to repeat. not the exact same issue, but the area. And when they begin to repeat, and you see that it's something you've been through, you've thought it through, you have a view about it, even if it's not on the precise question, you're less likely to take it, I think.
Can we talk about oral argument and how you went about preparing for oral argument and what role it played in your decisional processes?
Yeah, the oral argument, what happens is, okay, we grant cert. Now the lawyers begin to write. Got a blue brief, the lawyer wants us to reverse the lower court decision. The red brief, no, it was great. The yellow brief, filed by the blue brief, but that's the reply. Gray, the Solicitor General. Light green, any amicus, anyone can write a brief.
And you get quite a few of these days. A lot more than you used to get.
We used to get 5 to 10 to 15 in a case, maybe 5, maybe the whole number of briefs, 10, 15. It could be more. I mean, the right to die case, it was close to 100, I think. 80,
yes.
Something like that. All right. I have this stack of briefs before oral argument. Oral argument is the first 2 weeks of October, November, December, January, last 2 weeks of February, March, April. Okay, Monday, Tuesday, Wednesday, Monday, Tuesday, Wednesday. All right. By the week before oral argument, I have the briefs. They're little pamphlets. I mean, they're not brief. I don't know why they call them briefs, but still.
There used to be no
this time
word
I'm
limits.
going to read them.
There used to be no word limits until the late 1970s.
What?
There were no word limits on Supreme Court briefs until like.
Really?
Yeah.
God. Well, in any case, these go right to my office, to my desk. I'm going to now the decision process I've thought over time really is this. It isn't that my mind is a blank by oral argument. No. What happens is I read the question. No, I use the yellow brief first, actually, because
That's the reply brief.
What?
The reply brief.
Of course,
yes.
Because it says the same thing that the blue brief said, and it just says it more in fewer pages. So I read that first. Then I'll go to the blue brief. I read the question. When I read the question, I think I know the answer. I go through the brief. I think, yeah. Now I did know the answer. Then I read the red brief. Not so fast. Not so fast. And I'll read the SG. I mean, being open-minded, and I suspect this is true in any important professional decision where it doesn't involve you yourself. All right, a decision, it isn't that you are blank-minded. Being open-minded is not to have a blank mind.
Right.
It is to be willing to change when you see facts and you see arguments that, it was really the other side. And you can go back and forth. And then I go to my law clerks. And I say to my law clerks in respect to each case, I want you to write something that answers this question. Go look it up. See, be sure they're right. Be sure this one is right. Or be sure that one is right. Or there's another argument I thought of. Go look that up. And you can put anything else in your memo you want. And tell me how to decide it. I don't mind. That's fine. I want you to think about these things. And so I'll get a memo from them on each case. There are 4. I'll get a
One law clerk is assigned to write the memo. Yeah.
and I will get the memos. So the week before, a few days before anyway, I have read their memos. I have read the briefs, and then I sit down with them.
How about the amicus briefs?
Yes. Yes, the way I read the amicus briefs is, I hate to tell you this, Alan, but you're on the good side of it. I know who's right. After a while, you learn who is who. And if the AFL-CIO or the Association of Manufacturers, they filed a brief, and their whole point is to show which side they're on, frankly, that does, maybe their clients think that's a great thing, but it doesn't move me. It shouldn't move me anyway, and I certainly hope it doesn't. It's the argument in the brief. And so I know if it's the SG, I'm going to read the SG, And and I'll read through who's writing, and I try to get the ones that I think will be substantive and will answer questions that are in my mind. But I'll go through the others. Now, going through the others varies. I'll pick it up.
Yes.
I'll open the page. I'll read the.
You read the folio, the card copy of the brief. You don't read them online.
No, that's my age, but
Yeah.
I don't read it online.
Didn't the pandemic change you at all on that?
No.
They kept shipping the briefs up to you?
Correct.
Ah.
I want the brief, and I have my pen in my hand,
Yeah,
and
okay.
I'll underline some things and make a thing down here and put a question mark, and I want to be sure, and I can't be 100% sure because, you know, if I read through the table of contents, I'll always at least read the table of contents. And the table of contents, it tells me that says exactly the same thing that the last brief said. This is his cousin. I probably, all right, 5 minutes. But I get a feeling there's something in there, and it can appear, my law clerks could tell me you should have looked at that one. Or I might sometimes, and I do sometimes tell them, you better look at that brief.
Yeah.
I mean, Mitch Kapor, I remember this particularly, we had a case called Google versus Oracle.
Oh, yes.
Right, 2 years that took.
Yeah.
Why?
Because it was a hard
It was
case.
assigned to me.
It was a hard case. It was a hard case.
very hard case, and it was about, you had to know the Java language. You think I knew the Java language?
No,
I mean,
no.
I started off, I thought Java was somewhere near the Indian Ocean. I mean, this is, yeah, you better know it. You better find out the relevant parts. And that takes time.
Yes.
And so that one of the, Mikey went around and got up the gurus that even I would have heard of. And so I figure at least these gurus are going to tell me correctly what part of the Java language is relevant to this. They're not going to say something that's wrong in respect to their technology, you say. So that was helpful because they're trying to explain to sort of a neophyte, to say it politely,
Yes.
In this area, how this thing works. And one of the lawyers, for example, had a brainstorm in a patent case, and he got everybody to agree, all the lawyers and lower court judges, to put motion pictures of the patented invention online and to say it was all right if we looked at them. And we did. I mean, I did. And you could see how the invention worked, and I never would have been able to figure that out from the written word. So that was not a bad idea. But I will read the briefs until I'm satisfied I know what they say. And usually that means reading or at least looking at all of them, including the amici, and then we have the law clerks to talk to, and now I'm reading their memos, and I might go back to something, or I might not, it depends on the case, and then I'm ready for oral argument. Or what happens in oral argument?
Can I ask you a question first?
Please.
Do you discuss the cases with your fellow justices before oral argument?
Rarely. Rarely. I learned that in the First Circuit. I learned that a discussion, an oral discussion with another judge in a panel is risky. Why? Because I was talking to, maybe it was to Ray or something, we were talking about something, and halfway through the conversation, we suddenly realized we were talking about two different cases. You see, the written word there is important. So be careful. And it's particularly difficult in the Supreme Court because when you say something, whether you like it or not, it can be taken by the other judges as a kind of commitment, at least to how you're leaning. So be careful of that. And so putting all that together, it's not never, but it's rare. And I'm more likely to put something, if it's a discussion that I'm interested in, say, I hope you'll pay particular attention to this brief or to that.
In a memo?
Yeah. No, maybe, no, I won't do it in a memo, not before. Unlikely, unlikely. But I might see, I'm thinking of something where I was talking to Tony about something. I said, read that, that's pretty good. Or he might say, you know, but it's unusual. It's not the norm. You go into the oral argument, and the preparation is pretty much what I've just said. And then I learned over time, I don't know if it's a personal matter in part how you work, but I thought, and that accounts for a few crazy questions I asked. I don't prepare the questions, nor very rarely would I prepare the questions.
Interesting.
Very rarely. And something would come up, or I'd have in my mind a problem. And the best kind of question, I think, is, I can't prove it, but I think the best kind is, I don't know the answer. I really don't. I want to find out. And I want this lawyer, I think he knows, or has a view anyway, and I want to hear what he has to say. Now, what I could be trying to do sometimes, rarely do you succeed at this, but go look in the Second Circuit. In the Second Circuit, interestingly enough, learned at hand, and I think Jerome Frank maybe, designed the bench. And they designed it so that you're at the same eye level as the lawyer. And Warren Burger did something roughly similar with the
Yes.
Supreme Court bench.
And they moved, it used to be flat across.
Yeah.
They couldn't see each other and you couldn't see, it was hard to see them. And it's now in a
Now it's, yeah. And what you're trying to do, which the lawyer resists, you would like him to forget, which he won't do, forget that he's representing someone. I can't say that happens very often. But you somehow, and you can somehow tell that you actually establish a conversation. You actually establish some questions and answers where you feel we're making some progress here. Say, and that's what I think doesn't always happen, certainly doesn't happen too often, but sometimes you do. Sometimes you do, and then you feel, well, that was particularly worthwhile. A second thing that oral argument can do is it can allow you to say where you're coming from, which then your colleagues see where you're coming
Yes.
from. You see where they're coming from.
Beginning of the conversation.
Right.
In check.
And then the third thing is you want to make a joke or something, don't do it. Don't do it. The oral argument is not about you, the judge. It's not. It is something carved out of time and space, something that maybe gets a little progress going. Now, how often does it change my mind? Not too often on the result. But wait, it changes it not so more often than you think on the way to look at the case. And that matters, even if it's only part of the case. Or why does it matter? Because that a lot of how you write the case depends, of course, on how you look at it. And the law, what is the law? The law is very often the lawyer in the next case, or in his law office, or whoever in class, reading this opinion and taking what it says, not necessarily the holding. The holding can be very important, but so can the words that are used. So how you look at the case is important. And their oral argument, you say 15% of the time, 20% of the time, maybe more than that, changes how you look at it. Now, it changes your mind from A to B, or A to not A. Say A to not A, 5%, 10%, more rare. But oral argument, to me, is very important. Don't go around telling jokes. I've said some idiotic things in oral argument, but so what? So what? What you're trying to do is make progress. My worst one, I think, I liked it, but no one else did. A rare case came up, which you in the law schools will know, because Lon Fuller used to write about it. He wrote in his jurisprudence books, he wrote about, he says, well, suppose there's a sign in the park saying no vehicles allowed in the park. Does that sign apply to a Jeep used as a war memorial? All right, so that was the situation. It wasn't a Jeep, it was absolute. So I remember my class, Law and Fuller, he had that. And I started asking it. I said, suppose you're in the park and there's a sign and it says no, and then I couldn't remember it. So I said, no animals in the park. He said, yes. The lawyer says, I said, I couldn't remember what it was. I said, does that sign apply to a pet oyster? The lawyer said, what? Rehnquist, who never did this, Rehnquist looked over and said, he looked at me and he said, did you have a pet oyster?
I want to turn to talk about the book a little bit. I don't get to ask justices questions very often about the court. But many of the reviews of the book have been very favorable, as they should have been. But there are two kinds of criticism. I'd like to hear your thoughts about them. First is that the book is largely a detailed discussion of a lot of the cases, with a lot of the facts and the law and so forth and so on. And for those who are not lawyers, you may be losing your audience. Why?
Why?
No, why would you lose your audience? Or why did you feel it necessary to go into such detail with these facts?
Because I want to write a book that's one major purpose, really. I was a judge for 40 years. I still am a judge. and 40 years. I would like to think back over it, and what have I learned from all this? That's a great line, by the way, in Turgenev. When she dies at a young age, he says, what did she learn from this life? All right, I want to explain. Now, by the way, I can talk some of the theories of textualism and originalism and so forthism, but I know there are 100 or 200 or 300 law professors that if you really go into the theory of it, they know more about it than I do. You say, and they'll know they know more about it than I do, I promise you. But I've had some experience they haven't had. And so what I want to do is write the book out of that experience. And I want to say there is a kind of traditional way, a global way of looking at how to decide a legal case of a certain kind, of the kind that I describe in the book, and I'll show you. I'll show you why I think. Going back to maybe Holmes or Cardozo or John Marshall. I have a chapter on John Marshall. Going back, they knew what they were doing. And of course they'd look to history. And of course they'd look to text. You know, if the word in the text is vegetable, that isn't a fish, all right? But they'll also look to purposes. What did Congress, what did they have in mind? Someone wrote these words. Someone. What did they have in mind? Let's try to find out. Or what consequences will there be in terms of purpose, if you can, if we decide this way or that way? Or what are the values that underlie this if we look at this document, the Constitution, which is still there in my pocket? Yeah, and it has certain values in it, corny but true. Democracy, human rights, you know, equality, separation of powers, rule of law. The country's built on that. The 320 million people who live here, that holds them together, certainly helps hold them together.
And how does that fit into your detailed discussion of the cases?
It does. It's there. It's there. It's there. You get a case. It's partly the human community. And now you say, oh, this is so vague and so corny. It leaves the judge free to do anything he wants that's good.
Yes.
Yeah, that's what they're afraid of over on the textualist side. That's what they're afraid of. And I try to show here, no, that's not true. Or at least it doesn't leave them any more free than textualism. It doesn't, if a judge wants to do anything he thinks is good or to try to stay away from the law, then you're not doing the job right. And you can do that, whatever theory you have, but don't do it. All right, but anyway, so that's why I want to write the cases, because I want, insofar as possible, to put the reader in the position that I actually was in. And I try not to downplay what the opposition, because most of these cases had dissents and so forth. Yeah. And I don't want to downplay or underrate what they're saying. So I want to say what they were saying and say why I didn't accept it, and then show people in either the constitutional case or in the statutory case. And that statutory part is an important part of this book, though. I agree that people who aren't lawyers and so forth will have to work a little bit to get, but you know, in a case, even a statutory case, if you put your mind to it, you can get to the bottom of it pretty quickly, if you really want to. And I hope that some of the non-lawyers will.
If I'm right, does the detailed discussion of the facts in the case and show you why your approach, in your view, worked better than the other approaches? Is that what you're trying to do?
It depends. I put it in for that reason.
Yes.
I mean, the case I put in, which is really an easy case compared to most of them, I thought, if you have a handicapped child, you can require, under federal law, the school board to give special treatment.
Right.
Right. And suppose, in your opinion, the parent, they're not doing it well enough. You can sue them. And if you win, they have to do it, of course, but in addition, you're entitled to your costs. All right? Costs. That's what the word is in the statute. Now, people can understand that, and the facts of this woman who's in our court has had to pay $29,000 for the educational expert that testified, and she won. Yes. All right? So she says, I'd like the $29,000. That was part of my cost. And the question is, what does that word cost mean? And I say, I use that. Now I brought them up to speed. I'd say, does that tell you? Some people thought, the school board thought it just meant legal costs. Maybe filing fees, maybe the lawyer's fee too, but it doesn't mean non-lawyer's fees such as an educational expert. The other side, which was me, thought it meant educational experts too, given the purposes of the statute and the difficulties of proving these things. Okay, people can understand that. And they can also understand my slightly sarcastic point, though I don't put it this way in the book. I try to be as polite as I can, even though I don't. Maybe that isn't too much. But nonetheless, I try to do that. And I say, okay, let's try a textualism, because Scalia at one point, who's a good friend, but he says, no, don't look at purposes, don't look at consequences, they're too hard to find, just read the text. So I say, okay, I'll do it. I mean, I don't say that in these words, but I say, look, good, let's word it. You know what the word is? Costs. That tell you the answer? Well, let's say it louder. Costs. Okay, let's try it 3 times. Cost. Hey, we're still not there, are we?
No.
So maybe we better try
We should get a dictionary open.
costs. Yeah, it tells us in the dictionary. Oh, that's really helpful. We didn't have a problem knowing what the word meant. We had a problem knowing its application.
Yeah.
We had a problem knowing the scope of the word.
And you had to understand the context in which it arose.
Correct.
And
And I want people to see that. I want them to see that, and I want them to see that this cost case is honestly the easiest case I could find on this. What's the case doing in the Supreme Court if it isn't harder than that?
my office was on your side of that case.
Oh, really? I
Yeah,
didn't know that.
My colleague
I didn't
David
realize
Laddick, yeah.
well.
So we agreed with you. Will.
All right, thank you.
So the second criticism I have of the book is that you assume that everybody looks at and decides cases based upon the legal arguments and the facts and the law in front of them. And there are many people today who accuse at least some members of your court of having an agenda, of deciding what they wanted to decide and don't have an open mind. And your book almost naively assumes that you can reach those people.
You can more than you think. That's been my experience. It's because what is it really what I got just when you said? They don't put it the way you said it. You put it in a very polite way and a more reasonable way.
I try to be
what they're
polite.
thinking in that audience is, no, it's all politics,
Yep.
please. Forgive me, it's all politics. It's all politics is a waste of time. And to that I say, all politics, one, that's the wrong word. Politics is not the right word. And two, it's more open, in my experience, which ended 2 years ago there. But it's more open than you think. Politics? I did work for Senator Kennedy for 4 years. This is politics. I mean, I go back to my office one day, the counsel at the Judiciary Committee, and there's a young woman going through all the papers on my desk. And I said, excuse me, is there a reason you're reading all the papers on my desk? And she said, yes, I'm a student here, and I'm studying the Judiciary Committee, and I want to see how you decide things, so I thought I'd come in and read the papers. Well, I got a little annoyed. And I was about to say something rather biting or slightly unpleasant, and then the thought crossed my mind, maybe she's a constituent. Yes, I was more polite. And politics is that. Kennedy gets a phone call from the mayor of Worcester at the same time as from the Secretary of Defense. Which will he answer first? I know. It's not going to be the Secretary of Defense. And are you Republican, Democrat? What's the reaction to this? What will the papers say? What will the newspapers say? What will my constituents think? How will it be billed? Is it going to make me more popular over here or there or the other? That's really politics. And I do not see that on the Supreme Court. In 28 years, I didn't see it, and I didn't see it for 14 years over in the Court of Appeals either.
So how about not politics, but ideology?
Yes, I think ideology does play a role. I think ideology does play a role, but you lose it pretty quickly. Completely? No.
Well, we are.
You're brought up a certain way.
You
I grew up.
You are, right? I mean, you can't walk away from everything that happened when you were growing up and going to college.
Exactly right. I discovered the president of this university and I went to the same high school. Fabulous. I didn't tell her, but I remember coming in my senior year where we did nothing but go to the local swimming pool. I said to my mother, I've never been as happy in my life as Fabulous. Why? Because we spent half the day at Marin Town and Country Club lying in the sun. All right, but that's San Francisco. But I grew up in San Francisco. I went to Lowell High School. That's true. I've lived the life I've lived, and you all have too. And by the time you're in your 40s or your 50s, you will see. You'll have views. You'll have views. Maybe they're inarticulate, but there'll be views about your profession, about your country, about the city, about all kinds of things. And you think you can escape them? You can't. You can't jump out of your own skin. You can't do it. You can try. You can try to keep them at a distance. And I first thought that was terrible because I thought, why doesn't everybody here on the Supreme Court agree with me who am so reasonable? And then after a while, I began to think somewhat more maturely. And I thought, it's a big country. It's a big country, 320 million people. They all think different things, and they've got to live together. And having people who think different things in that kind of way, of how you grew up and where you came from and so forth and so on, that isn't such a terrible thing. That's there. Ideology is there. Sometimes, like as in trying to enforce Brown versus Board, we know that political consideration, how are we going to get the South to do this? How are we going to get this part of the South? Because the only people out there trying to enforce Brown v. Board for 10 years really was the courts.
Yeah.
Yeah. And they had to try to figure this thing out. I bet in the Fifth Circuit, which really integrated a lot, it was, so sometimes that sort of creeps in. Yeah, but pure politics, no. And sitting around the room, we sit in that conference room, and it's still true, because I've asked people who are there now. In the conference room, we're there by ourselves. We speak in order. Nobody speaks twice till everybody's spoken once. Then you go back and forth. And you try to make an argument in the form of, I have a better argument than you do, ha, ha, ha. Forget that one. That'll get you nowhere. It just leads the other person to say, no, I have a better argument than you. So you better listen to what the other people are saying, where they're coming from. And when you figure that out, you then can sometimes bring people in. You sometimes can, because they're trying to get more than 5, at least 5, but more than 5, if possible. And that was my experience for 28 years. And sometimes, somebody might say, no, forget it. We can't. We're just disagreeing on this. And then we are. All right, but making an effort in that room. And I've said I've never heard a voice raised in anger there. That's true. And I think it's still true. And I've never heard someone say something mean or about another justice, not even as a joke. You can go home and complain to your family, but not there, no. It's professional. You go around. I like the rule, nobody speaks twice till everybody's spoken once, because I was junior. For 11 years, I was junior. I almost hold the record. I still do for a 7, Joseph Story beat me by 11 days. All right, so I thought of writing to Alito when he was nominated and saying, will you please wait 12 days until you... But I missed my chance to go down in history as an answer to a trivia question. And there we are. But I like that rule. It's a very good rule. Everybody feels he's had a chance to be heard. And then we go back, and the chief assigns the opinions at the end of the 2 weeks, or 6 days of oral argument. It was 12 cases, or sometimes less, but yeah. It could be. But he's not totally free to assign the cases anywhere he wants. Everybody writes 1 before anybody writes 2, and then 2 before 3, etc. So he has to keep that in mind. And he won't be assigning it unless he's in the majority. The senior justice in the majority will sign. And then he wants 5. So I learned after about 6 months how to get a case assigned to me, guaranteed. 4 people are on this side, 4 people on that side, and then it's my turn to speak. 3 words I can guess, get it assigned to me. You see what the 3 words are? All I have to say is, I'm not sure. They have to assign it to me. So, however I decide will be where the court goes. All right, but you see, I learned that and then stopped doing that. I never said I'm not sure. That's why Sandra says never in doubt. She used to say that. But anyway.
So the book is called Reading the Constitution, but the first third of it is about statutes.
Yeah.
Do you think that you read them the same way as the
No.
Constitution?
No. Constitution, John Marshall said, which is right, is more abstract. It's more general. It doesn't go into the details. That's why I put a chapter in there of 6 different things, he said, in McCullough versus Maryland, which I think is an important, maybe the most important case on interpreting the Constitution. And one of those 6 things, which is very important, he says, you know how many times it says bank in the Constitution? And the question was whether Congress had the power. Yeah, to create a Bank of the United States. Correct, the answer. He knows a lot of law. You say 0. 0. But he said that's not decided in the case. Because, of course, it's a constitution. Yeah, that's why that's
Yes.
written.
Oh, yes.
The
He says that.
Constitution we are expounding, and of course it would be written at a level of abstraction. But still there are principles underlying those words, the freedom of speech, the right to bear arms, etc. And you try to understand, where is it driving? What did you think that's a question that was answered in 1789, whether the owner of a shopping mall has to allow somebody to come in to hand out pamphlets? No, they didn't have shopping malls in 1789. I didn't know that, but I learned that. And by the way,
Even in
be careful.
California, they didn't have them back then.
Yeah. No, in California, I think they did. No, they didn't.
It wasn't California.
And you have to remember, keep in mind this, when you want to go back, that's originalism. So originalism is textualism, but it says you go back to look at what the words meant to the ordinary person in 1789 or 1870 or something, when those words were written. I said,
What's the problem with that? What's the problem with that?
There are many problems. One problem is, well, one big problem, a serious problem, is there happened to be 50% or probably 60, 55% of the population that was not part of the political environment at that time. All right. You see the point. You see the point. That's just one problem, but it's a big one. And another problem with going back is, Nino DeScalia, we were good friends, and we used to discuss this publicly. For example, we went to Lubbock. In Texas, or in a football stadium, everybody came out. They hadn't seen a Supreme Court justice, or I suspect they thought we were going to play a football game. But nonetheless, we would debate these things, and people saw we were friends and got on well, but we had different points of view. And I would say to him on this point, I would say, you know, really, Nino, George Washington didn't know about the internet. And Nino would say, I knew that. And he'd say, and then he'd say, but it's more like this. It's more like the two campers. One sees the other putting on running shoes. He says, why are you putting on running shoes? He says, there's a bear in the camp. He says, a bear in the camp? You can't outrun a bear. Yes, he said, that's true, but I can outrun you. And then he would say, which was really at the bottom, I think, of the disagreement here. He would say, you know, Stephen, because he came to the conclusion after a while that I'm serious about what I'm doing and I mean what I say. He said, but you have a system, and he's thinking of looking to consequences, looking to purposes, trying to find them, looking to values, seeing how they're consistent with other values that we hold in this country, and so forth, and looking at all those things. He says, it's so complicated, you're the only one who can do it, meaning maybe I can't. But that's what he says. So that's, I think, a basic complaint of the textualists. That's what they don't like. Too complicated. But I say, I try to show it's also the other. Here, theirs is complicated too. But more than that, I say that, well, that's perhaps there is something to that. But on the other hand, if we take your system, we're going to have a constitution that no one wants. You say. And I think maybe 20 years from now, somebody will know who was right about that. And of course, here I think I am, big surprise. This book could be called Why I'm Right and Everybody Else is Wrong, but I felt that's not
Your publisher wouldn't let you say that right
no.
now. So I have a big question for you, and that is, the question is this: where do we stand with stare decisis on the Supreme Court? That is anything sacrosanct anymore? Is everything up for grabs? Some people say that that's what the court has said in the abortion case, in the affirmative action case, many of the First Amendment cases involving religion, that these have been radical changes. And what do you think, where do you think we're going with stare decisis, and why do you think stare decisis is an important part of our jurisprudence?
Well, when I discuss that, I think this, that I think the textualist is very, a tidal wave, I call it, coming along. Not just on the courts, and not just on the Supreme Court. The law schools, somewhat. Federalist Society, somewhat. Other societies, yeah. All over the place. I say, what's the appeal? The appeal is they make 4 promises, and that's one of them. 1, you'll see in a second. This is simple. Just read the words. 2, it's fair. Everybody will come to the same conclusion across the country. 3, it'll help Congress because they'll know what to expect. And 4, the judge will be hemmed in trying to substitute what he thinks is good for the law. I said, those are very great promises. Unfortunately, none of them can be kept. As far as the certainty and everything, everybody the same, just try the cost case. The cost case was the easiest one I could find.
How about the recess appointments case, when the case, 2 words at issue were may happen and thee?
That's right.
In the
And
Constitution.
there's another case too, thee. What does thee mean?
Yes.
But I can't remember the name of that. That came out recently. I
Yes,
wasn't involved.
it's a statutory case, yeah.
Please, spare me. You can't, I mean, no, you can't do that.
68 pages of what is the meaning of thee.
I mean, I think I'm on pretty strong ground there. But what about this 4th one, which has a lot of appeal, about the keeping the judge under control? After all, it's Congress. Well, I say, look at Dobbs. Dobbs is the abortion case. I joined the dissent, 3 of us, Sotomayor, Kagan, and I wrote a dissent. And probably there were 1,000 arguments why they were wrong. There weren't 1,000, but there were quite a few. But one of the arguments was what you say. I go to the textualist, and I say, you were willing to overrule 2 cases, one of which was in the law for 50 years and the other for 30 years. You were willing to overrule those. Now, stare decisis is not complete. There are exceptions, Brown v. Board. There are exceptions, but the exceptions are rare. And if you go, sometimes you can find the law has changed anyway. You could find that this hasn't worked out the way the court seems to have thought it would. Sometimes you can say, look, no one's relied on this and it won't hurt. There are reasons. But what are those reasons here? I don't see them. That was the argument that we made. So is it that you're prepared to overrule any case that does not follow textualism or originalism? No. They're going to say, no, that's not the basis.
But what's the line?
Why? Why are they going to say that? Because if, and that's what you're implying in the question, if you take that as a basis for overruling a case, there isn't going to be any law left, because nobody went into this textualist, originalist thing until the 21st century. I mean, very few. They're all decided on other bases. So is suddenly every case open? I know the answer of the textualist. That is no, that wasn't the basis. Well, what was the basis then? The basis for overruling it seems to be, this is just my opinion, but it's shared, that the majority thought that Roe and Casey were very, very wrong.
Egregiously wrong was the term that Justice Alito used. How do you know? Do we have an egregious meter that tells you when to go too far?
Oh, wait a second, you see. Because what I use that argument for, I say, how do you know? But I want to say something slightly different. I want to say, aren't you, Mr. Textualist, in using that as a basis, in exactly the same boat that you accuse the non-textualist of being? I mean, what's your job? You're a judge. Very well, you, the judge, have to decide whether the prior case was wrong enough to be overruled or right enough not to be overruled. And doesn't that open the door completely to exactly what you're accusing the non-textualist judge of being, of having the opportunity to do and doing it? Hey, deciding what you want is good compared to, or bad, you see, compared to, rather than applying the law. So aren't we all in the same boat on that? You can either do your best not to do that or not. And there's nothing special about textualism that gives you any advantage one way or the other there. See, you see the point? We're in the same boat. That's all I need in order to say your point, that you're going to rein in the judge who's off on what's good or bad, isn't a very good point, because we're in the same boat on that. You can do the same thing right there, right in the question you posed.
Well, let me ask you one last question about history, and two kinds of history: legislative history for statutes and constitutional history for the Constitution. Do you see any tension between the textualist positions on those in terms of what we see and how the cases are decided? Do you think that you would consider both the legislative history of statutes and the legislative history, the constitutional history, that is what happened before in deciding cases? How do you view history in terms of?
Can you bring that in? Yeah. I think, will the reports in the Congress tell you the answers to the question of purpose? Often, but not always. And if they don't tell you, or you see that it was disputed in Congress and so forth, what the purpose is, then turn to something else. But sometimes, I think fairly often, more often than is recognized now. What about the history then? Why don't I use the history in the Constitution? And the answer is, of course you would. Of course you look at it. The real argument in Heller, the gun case, the first gun case, was about that history. What is it that, why a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Majority. There's a comma after state, and so what they were saying was the right to bear arms, and the right to bear arms included keeping a gun under the pillow for a burglar, in case a burglar comes, all right? John Stevens wrote a dissent on history, which I joined. He said that wasn't what this was about. What this was about was people were going out saying, don't ratify the Constitution. Quite a few. Came close. And one of their arguments was, look at Article 1. It gives Congress the power to call up the state militias and regulate them. Well, they could call up the state militias and disband them, and we'd be left with a federal army. How terrible. And what Madison thinks is, never fear. We will put an amendment into the Constitution which says the militia is necessary for the security of a free state, and therefore the right of the people to keep and bear arms, which means have a militia, shall not be infringed. So they can't disband it. You see? No problem. Vote yes for the Constitution. That's John Stevens' point. So the question is, who's right about that history?
Didn't they argue about the same evidence and the history on both sides?
Yes.
Yeah.
Yes.
And
I mean, I think sometimes, just like legislative history, sometimes it answers your question and sometimes it doesn't. But truly, there's nothing wrong in reading the history and use it for what it's worth. And in my opinion, it was not worth too much in that Heller case. And later on, when the court decided Bruin, and they went back into the history to decide whether you can have weapons outside the home, and the argument of the majority was just look back into the history, period, and nothing else. I said, oh, really? We look back into the history to see if this was regulated long ago in history? Well, I looked up. I did find this on the internet. I didn't put the word internet, in my opinion, but it was fairly obvious that I got it from somewhere. And I said, well, in the 100 Years' War, they used still ladders, halberds. I guess you all know what a halberd is. No. Halberds, still ladders, Asian fire. You threw it over the wall and set the house on fire, or the town on fire. I said, judges can't do this. I mean, we can read the briefs, yes, but we don't really know. We're not historians. And we're really going to look at that kind of thing alone? Alone? No. We shouldn't do it. That's one reason. That is one reason why I think that approach is not very helpful, and was not helpful in that case, but it was a dissent.
in the dissent.
In the dissent, I wrote, and there were a lot of other things, and you can read it. I mean, we went through, and I tried to explain why history didn't reach the result that the court reached, and of course they thought it did. But there we are. I think it is not helpful for one reason being that judges are not very good historians. And in Bruin, someone filed a brief, a group of linguistic historians, and they said in that brief, we've looked up the use of the phrase bear arms in the years 1760 to 1790. And we have found, I think it was something like 120,000 instances in which that phrase was used, bear arms. And in all of them, except for, say, 5 or 10 or a very few, it referred to militia. So I mentioned in conversation to one of my colleagues, because we get on well, I said, well, so we should overrule Heller, right? Because it was obviously wrong. And I said, yeah, ha ha, okay. But
So the historians can't even agree among themselves.
yeah. Well, the historians were on the side of the dissent, I think. But of course, that's hardly surprising. I think that I thought the dissent was right. I do think it's right. But I don't think it's a good idea, whether you think that dissent is right or wrong, to turn everything on history alone. Among other things, I've said there where half the population wasn't even involved in the writing history. Okay.
If William Rehnquist were the Chief Justice and presiding over this conversation, he would have ended it on time. But he's not. And so I have extended it, but I fear that I've extended it already too long. And so I want to thank Justice Breyer for coming and giving us this wonderful elucidation.
Thank you. You're going to have questions? You can have questions if you want.
We don't have time.
I don't care.
There are many wonderful questions. I'll ask you one.
All right.
This is a question from a law student, Jason. Said, can you think of a time on the Supreme Court that something happened that made you smile?
When Justice Rehnquist looked over and said, did you have a pet oyster?
Thank you again very much, and thank you again, Justice Breyer.
You said you're not going to do any pictures here?
We could do some here.
Okay. I'm going to do some social engineering, if everybody would just humor me a little bit. How many students here are third-year students getting ready to commence on Sunday?
Excellent.
All right. Do you want to take a picture with the justice? All right, come on up.
All right, if you're third-year students, let me make an additional point. Because I do talk to a lot of law school classes, and I do talk to high school classes. And I say this only because of the time that you're going into practice. You're going to practice a difficult time for the country. We all know that. We all know that. And I can tell you why I'm something of an optimist, and I can tell you what Senator Kennedy told me when I started working there. And I tell this to the high school students, college students, law school students too. I'd say, what he said you have to remember, working in the Senate, and I don't know if that's still true, but working on the Senate staff, and I think it was an important point. When we're trying to do something and other people disagree, what you do as a staff member is you sit down and talk to them. You talk to them. You discuss the problem. Mill said the same thing. He said, talk to people who disagree with you, not the people who agree with you. Wait! Kennedy added one thing, don't talk too much. Listen to what they say. And you will discover, if you listen to what they say, they'll say something finally you agree with. You actually agree with it. And as soon as they say that, you say, what a good point you made. All right? And once you do that and you work with it, sometimes you get somewhere. And if you get 30% of what you want, take it. Don't hold out for something that's 100% that you won't get and all your followers will applaud you. Don't do it. And then, when you actually got somewhere, and the press says, Senator Kennedy, as they did, Senator Kennedy, you did such a good job with this. You say, don't thank me. Thank Senator Hatch, who came up with the idea that bridged the gap. Yeah. Okay? Got it? He says, credit is a weapon. If in fact the thing works, hey, there's plenty of credit to go around. If it doesn't work, who wants the credit? And do you know why I think that's a cause for optimism? What he told me and what I saw perhaps then, 20, 30 years ago, did work quite a lot of the time. Why is it a cause for optimism? Because when I say this, just what I told you, exactly. When I say this to the high school students, suddenly there's a quiet in the room and they're interested. Why are they interested? because I've said to them, Kennedy, through me, to them, I've said something they actually can get out and do and help hold this country together. And that's why I told you that.
Okay, you're going to come up the stairs and stand behind the chairs, and you're going to do it really quickly. There's 2 sets of stairs. Come up and stand behind the justice.
You want us to stay here?
Yeah, I want you to
Okay,
stay
all right. Stephen, wonderful. Thank you. That's great.
Thank you.
We're so proud of you guys.
You're first. I guess.
Yeah.
That's good. Good.
Thank
guys
you so
come
much for
faster.
doing this. It has been amazing.
Oh, well,
Hey,
good.
hey, guys.
Thank you.
Is this going to work? Can you get everybody? So, how are you stand over here?
Yeah, come on down here.
Come
We
stand
can,
over here. Yeah. Stand over here. Oh, that's
Oh,
nice.
that's a good idea.
That's good. Come on this side. How many of you going to the reception? Okay, so as soon as you get finished, go ahead over there. Okay? Come over this side. Can you guys come over this side a little
Yeah.
bit? Come kneel in front. See how they're kneeling in front? Come kneel over there.
Yeah. Get in the front.
Please applaud them. If
Great
you're going
idea.
to the reception, go ahead over.
Thanks.
Stay where you
Great
are.
idea.
Yeah, you stay here for a second, because otherwise they're going to mob him.